started in a minute.
Near me, free room.
Dennis Woody has formatted this in such a way that he'll start us off and do it by asking questions. Most of the individuals here have some level of experience with guardianships, and what we want to do, we're starting just a little late, so we'll probably run a little bit over. What we actually are going to do is audiovisual is going to film this for us, and we're going to look to put it on the website, on the county website. If you have a question, and I hope that you do, as you know, if you've been to these round tables before, we try to make them interactive. With the filming of it, however, is somebody walking around with a mic, Alex? Does someone have a mic?
Not right now.
All right, so what do we, let's see. Who wants to volunteer to walk around with a mic when the time comes? Cindy will. And the reason is, the only way they're going to pick up the audio with the question is if you use the mic. So as we go along, Cindy, if you see somebody have a question, if you can run over and fire away. I think everybody knows everyone on the panel, but except for me, I don't know everyone on the panel, but I'll guess as we go along. The fellow on the far right is Dan Coleman. He's my law clerk. He really is the coordinator with the guardianships, and he'll talk a little bit more about some of the extra things that he does. Beth Stephanide, estate practitioner. Dennis Woody is he and Bill Halligan, of course, are the longtime law clerks for estate work assigned to the president judge. Dennis and Bill review just about every petition that you file, including your guardian fee petitions or the petitions guardians have to file. Beside me is Jackie Goffney, who has been doing guardianships now for a year or two and is very, very good at it. And she is one person that I'll tell people to call to ask for help. She's with Swartz Campbell now and a former assistant district attorney. Of course, next to Jackie is, everybody knows Jen Mataloni, our Register of Wills and our Orphans Court clerk. Jen and I have been working very closely together on a number of initiatives. And next to Jen is Carol Hershey. Carol Hershey is one of the principals in Guardianship Services, and Guardianship Services does a number of guardians in Delaware County. So with that, I'll turn it over to Dennis. It's 8:10 now, and we'll try to run this through 9:10. The program literally could take 2 hours, especially when you add somebody like me to the panel. Not even saying with Jackie Goffney. Jackie can't say hello. It takes Jackie 10 minutes to say hello. So we might run a little bit long, but we'll shoot for that 9:10. All right, Dennis?
Yes, good morning. About 2 years ago, the Pennsylvania Supreme Court formed a committee to look into the problems of elder abuse in Pennsylvania. That committee met for about a year and a half, and in November of 2014, that committee issued a very extensive report. It's a 284-page report on the problems that we face in Pennsylvania and really nationwide with elder abuse. That report you can get offline. I would recommend that anybody who's going to do a lot of guardianship work, whether you are the guardian or representing the guardian, that you get a copy of that report so you can see the concerns of the Supreme Court and the committee that was established by that Supreme Court. Madam Justice Deborah Todd was the one who chaired that committee. You can get it by just typing in on your search engine, Elder Law Task Force and the Unified Judicial System of Pennsylvania. As part of that report, or many parts of that report recommended, there were, first of all, a total of 130 recommendations that they have made to the legislature, to the courts, to the citizenry of Pennsylvania. But a lot of those recommendations dealt with training, and this, of course, is one of those things that should be done. They also gave a grant to York County through the State Justice Institute, and they asked York County to develop a program that could then be used throughout the state. In one of the handouts you have, it says Guardianship Training, What You Need to Know. That was developed by York County. It has not yet been fully accepted as the training program for Pennsylvania, but we discussed this matter with the persons on their committee, and they said even though it's been submitted to the Supreme Court but not yet fully accepted, I'm sure they're still working on making it better in any way they can, but they said that they felt it would be appropriate for us to use that as well. So we included that in your packet, and although we're not going to follow that paragraph by paragraph, basically we're going to cover many of the issues that are included in that packet. So what I'd like to do in getting started is ask Judge Kenny to tell you what he looks for in a guardian when a petition for a guardian is filed in Delaware County.
Right. First and foremost, a number of the guardianships that come through, under the law and under the Workers' Court rules, you're initially looking towards to appoint family members, people who have been in the life of the individual for a lifetime. And in many instances you can do that. But there are a number of instances that you can't. Sometimes family members aren't involved, haven't been involved. And most importantly, there are times when there is or seems to be alleged abuse. Okay, a lot of those cases come in through COSA, the county offices, services for the aging, and when you get those cases and you see that there's potential abuse, then there's a real reluctance to appoint a family member. And so that when I'm appointing a guardian, first and foremost, I'm looking to appoint somebody that I can trust. And secondly, I'm looking to appoint somebody who is very active. In other words, somebody that's not going to get stuck looking through the rules and regulations and the Supreme Court Task Force book because that could take days and days, and you don't have that. So you're looking for somebody that's going to immediately triage the situation, somebody that's going to get out from behind the desk and find out, first of all, why a guardianship was appointed, who are the people in this person's life, if there's alleged abuse, what type of abuse. Has it been physical abuse? Has it been financial abuse? Who are making the allegations? Finding out then where the assets are, and then determining what you have to do immediately to stabilize the situation. So a good place to start is with my law clerk, who really has become the coordinator for these guardianships and guardianship petitions, and that's Dan Coleman on my far right, and Dan will talk a little bit later about what he does. To sort of get the lay of the land, you want to immediately talk if there's attorneys involved for different family members, which quite often there are, talk to their attorneys and get their point of view. And you want to then find out where the assets are and immediately start changing the accounts and titles into the guardianship account names for the protection of the guardian. So when I'm appointing a guardian, especially an attorney, I'm appointing someone that's going to get involved right away, triage the situation, prioritize, and immediately stabilize the situation. And I really am looking sometimes, many times, I haven't just picked you out of a hat. It's somebody that has credibility that I know that under the circumstances, they are going to get in there and do the things that need to get done to stabilize the situation. And in terms of that, then you want to start putting your efforts into three different boxes. One I would consider an administrative box, the other one in ministerial and the other one legal. So for instance, you may open an envelope, and just opening that envelope, that's ministerial. So I'm just opening letters and sorting them out. That would be ministerial. Administrative is then, okay, I have to take some action here and do some things that somebody would do for themselves, but they can't do, like paying the bills, balancing the checkbook, whatever that is. And then, of course, the legal part of it, if you're appointed as a guardian, you're also legal. There may be a petition or something of that nature that you would file. And we could talk about that later in terms then of how you're billing. So that's generally how I look at it. First, you're looking at the family members. Then you're looking at the nature of the case and what it requires. Some cases, you're just going to put in one of the services that are available that I've come to rely on. But a number of cases, I'm looking to appoint individual attorneys because they have the skills that would go in right away and, like I said, triage the situation.
Judge, the guardianship statute says that you should prefer a limited guardian to a plenary guardian. I think as a matter of practice, that rarely happens. Could you just comment briefly on that?
Yeah, I think the concept of limited, quote-unquote, limited guardian comes from the concept of, that we are all aware of least restrictive alternatives. You know, you're always, because you're you seem to be taking rights away, so you want to do that in the most least restrictive way. That's why initially you look to family members to do this rather than somebody outside the family. However, as a practical matter, if somebody's incapacitated, there's rarely an instance where you can define where a guardianship is limited. And then when you try to define that, it typically runs into problems later, because then the guardian with the limited powers can only do so much, and then they often find themselves needing to file a petition to get authority to do some other things. So limited guardianship sounds good, but when you take it in the context of you're dealing with a person that you've defined as incapacitated, it's rare actually where you give out a limited guardianship. In fact, I can't think of an instance where I've done that. Where's Cindy with the mic? Rich wants you to stop eating breakfast and hand him the mic.
I just wanted to get it close to me. Thank you, Cindy. Judge Kenny, I have a question. In a situation with a suspected abuse of an elder person, if there's already an alleged power of attorney issued by the ward to a family member, and it's believed that family member is abusing that elder person's assets, and COSA believes that a guardianship, for incapacitation purposes, be appointed right away, what effect does the guardianship have on any power attorneys allegedly to be issued by the ward that are out there?
Well, in essence, once you appoint that guardian's going to be able to remove that principal agency relationship, because the guardian steps in the place of the principal. So the guardian's going to then walk in, take over the responsibilities of the power of attorney and the agency situation between the principal and the agent. And if there's abuse alleged, then they come in and ask for an accounting from the principal of the power of attorney.
So
and that's power of attorney we're going to talk about a little bit later, because power of attorney is the instrument that is most abused in terms of abusing the elderly.
Right, and would that be?
And the attorneys are the first line of defense on that. We've had seminars on that.
Okay, I'm sorry to jump in, but would the court-appointed guardian at that point have authority to revoke the POA that's out there?
Diana?
Your Honor,
Where's the mic?
Actually, it's a good point, because the guardian has authority to revoke the power of attorney, but the appointment of guardian doesn't automatically revoke the authority of the power of attorney. So a guardian, to be careful, needs to absolutely in writing revoke the power of attorney.
All right.
Carol Hershey, who's down here to my left, is president of Guardian Services of Pennsylvania, and her agency has handled literally dozens and dozens of guardianships. Her agency is kind enough to take a lot of appointments where we realized right from the start that there's no assets, that somebody's basically just providing a service. So a lot of times I'd be willing to guess right now she probably has at least a dozen people, maybe more, that she's guardian for in Fair Acres, where they have no assets, and basically under the statute she can get $100 a month from their Social Security. Obviously not a whole lot of money. She's providing a valuable service, though, to the citizenry of Pennsylvania. So since she has probably handled more guardians than most anybody else here, we asked her if she would explain for us what she does when first appointed. How do you get started?
Thanks, Dennis. And I think I'll steal Judge Kenny's word, triage is a good way to put it. Because once you have that court order, what do you do when you leave the courtroom? And many times when you're appointed guardian and you're dealing with an incapacitated client, they don't care that you have a court order. In fact, they might say they don't have a guardian, they don't need a guardian, they don't want you in their life. We've had many doors slammed in our face and, you know, basically people saying we don't want you involved. So what is your first step? I tell everybody, get the certified decree before you even leave the courthouse, if possible, or the next day. The banks are going to require, you need a certified copy of the decree. Investment companies are going to require it. Next step is the post office. If you have family, a former POA, or a client that doesn't know where their mail is going, loses mail, squirrels away statements in the house and nobody can find them, go to the post office, have the mail forwarded to you. It's the only way you're going to capture all the bank statements, accounts, bills. I mean, we've had a recent client, we were cleaning out our house and found old stale dated checks that hadn't been cashed in years. So it's the only way you're going to capture everything. Go to the post office and have the mail forwarded to you. And then the next step, obviously, as soon as possible, as Judge Kenny said, get out of the office, go see the client, meet with the client and any involved parties, whether it's family members, whether it's care providers, COSA, anybody already providing care in the house, and assess the situation. You'll see all over the instructions that are given out that to the extent possible you want to involve the client in the decision making. It's the way you're going to be most successful in getting things done if they're able to participate and in where they want to be, what they want, what type of help, who they want involved in their lives, whether there's conflict in the family. So meet with the client, assess their situation and how well they're able to give you information and to participate in the decisions. And then obviously go to the bank with your certified decree, especially if you've had information in the petition that there may be financial abuse. The bank is somewhere you want to go as soon as possible to, if necessary, freeze the account, get information about the account, get recent activity, show we've had clients in the nursing home and we go to the bank and for the last 6 months somebody's been making debit card purchases and cash withdrawals from their account. So shut down the debit card, freeze the bank account or close the bank account as soon as possible. And then I think Jackie's going to get into more of the estate issues, and the final point that I wanted to make is use the agencies available. COSA, the County Office of Services for the Aging, assesses, puts in service. They have a protective service unit if there is a case of self-neglect or a case of financial exploitation, so you can use COSA services if the client's in their home and they might need in-home services. And then the County Office of Behavioral Health as well. We have some younger clients with mental health issues that need services through the County Office of Behavioral Health. There's a mobile crisis team, so if I know one of the points that we talked about in planning this is that one of the things that a guardian is not allowed to do is commitment, an involuntary commitment to a mental health facility of our clients, so a 302. So there's a mobile crisis unit in Delaware County that will come out and assess the situation right there on the spot, and if somebody does need to be involuntarily committed, they will make that commitment.
Right. One thing I want to add to what Carol's assessment is, in terms of then when you're triaging the situation, you go to the bank, you see these what appears to you to be criminal activity in terms of financial abuse. The district attorney has set up now for some time a senior abuse task force, and they're actually here today. If you guys want to stand up. and I know Erica Parham is here too. So one of the things that you might want to think about is contacting Erica, contacting that unit, because again, one of the ways that we're going to manage this and stop the abuse is have the DA's office involved in investigating. And it's interesting because from time to time when you have these guardianship hearings or further hearings in terms of accounting and things of that nature, CID will be in the courtroom.
Yeah, some guardianships can be a real problem right from the start, especially when the person has serious psychological issues. Jackie Goffney is a former district attorney, and I know the judge has appointed her on a few situations where it was obvious that there may be criminal people trying to influence the incapacitated person. So if I could ask Jackie to comment on some of the problems she has experienced immediately upon being appointed as a guardian.
What I would suggest is when you make your first trip to the home, don't go alone, because no matter what that address is or what you think you're going to walk into, it might not necessarily be that. By way of example, I'm a guardian for an individual who lives in Bryn Mawr. Everything read okay on the paper. There may have been some bad debits on her account, and then I walk in and there is a mentally ill man in the house, a felon, an alcoholic, and they're taking over $10,000 a month from her, and she doesn't understand why she doesn't have any money in her account. They're also likely, when you're appointed, not very happy to see you because you are essentially going to stop their money flow. Don't be afraid to use local law enforcement. I've used Radnor Police Department. I've used Upper Darby Police Department. I'm regularly calling CID. You might have to work around their schedule, but they will be happy to come with you, assist you. Just this week, I had a daughter steal all her mother's silverware, and CID was happy to help me and get it back, given they already have a case opened with her.
Now, Carol said it well, that when you get appointed, sometimes you'll introduce yourself to whoever you're going to provide care for, and they don't want you in the house and they want any parts of you. A lot of the people that are being abused, they've developed relationships with the people who are abusing them. You know, so they're walking them down to the bank and they're taking $2,000 out of their account every day, but hey, these are my friends. So we had a petition that came back into court, and the incapacitated lady, very nice lady, said to me, Judge, do anything you want. Just get rid of that woman. So I knew Jackie was the person we needed in place.
Yeah, a lot of times when you're appointed as guardian, you may not think initially about using other professionals. You know, you might think, well, the judge appointed you as the guardian, you're the attorney, so you ought to be able to do things. Don't assume that the court assumes that you have the ability to do everything. In terms of finding the assets, Carol mentioned, you know, getting all the information from the bank and getting the mail changed. Another thing would be to look at the last couple years' tax returns to see where she or he, the incapacitated person, was receiving assets. Contact the accountant, have the accountant involved. And I know a lot of the issues are psychological, and Carol, if you could just comment for a minute, because I know that you have a psychologist on staff, I believe, or at least have a nurse on staff.
We do have a nurse on staff. So an RN who has many years of experience, has worked with dementia, worked at Crozier and their adult day program. And so she will get involved and, if necessary, get a further geriatric, psychiatric involvement or psychologist to assess our clients and determine, again, how much can they participate, how much are they able to give us in terms of information if they are being exploited. Because we have clients that say, oh, they'd give their kids anything, and it was my choice. I wanted to give them this money, or whoever is doing the exploitation. So we do use local geriatric psychiatrists and psychologists and our nurses very involved in talking to doctors about medication. Sometimes our clients may be over-medicated, sometimes not medicated enough. So it is helpful in your situation, since you won't have a nurse on staff, to talk to the medical providers, talk to the doctors, find out, hopefully, a physician who's been treating the person for a long time, maybe get some insight into their situation, their condition, what they can do. I mean, sometimes you're going to be making a decision about whether it's safe for that person to remain in the home, and if they can remain in the home with care, or if they need to be in a facility and what level of care. And again, that's when you get the other professionals involved. COSA does a level of care assessment to determine what is the appropriate level of care for a client, whether it's home care, assisted living care, or personal care, and nursing home care. So you're going to, as guardian of the person, be getting involved in where is the appropriate and safest setting, but still keeping in mind that least restrictive alternative. I think there's a question over here.
I don't usually need a mic, but this question goes along with what you were just saying. Where do you draw the line, this is something I ran into, between a pattern of giving that they've already had to a church or to a family member, and to protecting their estate once they've cross the line into being incapacitated?
That's a good question. I think we have had situations, and I think maybe Dennis or Jackie will get into this later, about you have to get court approval you have to petition for permission to invade principal and to gift money. So we have had situations where we've had clients with disabled children, older adult. I mean, their kids are adults but disabled, and lived with them for all their life, and they've taken care of them, pretty much funded whatever they did, and gave them money. And so we have, in a handful of situations, sought and got court approval to continue that. We usually try to set a budget. I mean, one example, our client was in assisted living. Her daughter was still living in her house with grandchildren. The client had taken care of her for pretty much all her life. And so and the lady had enough assets. So we got court approval to continue to pay the expenses of the house and give a stipend to the daughter each month. But again, it has to be approved by the court, and the person has to have enough assets, because if you're getting into a situation then with nursing home and Medicaid, then it's going to affect their Medicaid eligibility if you're gifting too much money.
When you approach the accountants or the physicians, do you ever have a case where the accountant or the physician says they're not going to reveal any of that information because it's confidential information? And if they do, how do you deal with that?
Once in a while we do. Usually your court order should be sufficient. I mean, you have a court order I don't run it in too much in the medical field. Where we run into it a lot is in mental health services, because there's mental health laws that protect clients who are mentally ill. And we've had clients that we're guardian for, and I've had psychiatrists and mental health providers say we have to get a release signed by our client to get information. And we try to explain to them, we are the guardian, we are the person acting on their behalf, stepping into their shoes, and they need to communicate. But not so much with the doctors. They're usually willing, once they have the court order showing that we're guardian, to communicate with us.
Yeah. You can also ask the Internal Revenue Service for a history, and I've had them go back even up to 7 years. So that's very helpful if the client or the incapacitated person has not even filed returns, or if for some reason the accountant is not going to cooperate. And if the doctor is really not cooperative, then present a petition to Judge Kenny, and we've done this, where he then basically authorizes the doctor to release the information needed. So, and he's done that without the need for a hearing, because you need to get that information right away. So there's some options on how to deal with.
Sometimes you have institutions or individuals where they don't understand the nature of the guardianship. So if you have to file a petition, you come in and I'll give you a court date and say subpoena the person to court with a custodian of records. Tell them Judge Kenny said if you don't show up with the records, he's sending the sheriff out. Or you can give me the records now. What option do you think they usually select? So it's typically a misunderstanding. So guardians and guardian ad litem, by the way, have significant powers to get those documents.
Judge Kenny, well, Cindy's getting the microphone there. I do have a question, and Jackie, you've probably run into this too. We have occasionally run into situations where we're appointed guardian and there's a spouse, so they may have joint accounts. I have a situation right now with the bank. We were appointed probably 2 weeks ago. Our client's in the nursing home. The wife is in the community. We went to the